Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey.
It is great to be here.
So, today we are looking at a scenario that, honestly, it sounds like should be an absolute slam dunk for a plaintiff. I mean, imagine an employee who genuinely believes he is being bullied out of his job.
Right.
He gets completely locked out of his computer systems. He is publicly mocked by management. He's literally told to go cry to the rival political leader.
Which is just a crazy thing to hear at work.
Right. And the escalation reaches this point where he is literally escorted out of City Hall by armed municipal police officers.
Yeah, it's a very dramatic exit.
Extremely.
Yeah.
So he files a federal lawsuit alleging political retaliation, and yet a federal judge throws the entire case out, like permanently, for a complete and total lack of evidence.
It happens way more often than you'd think.
But how? How does a victim with what seems like, overwhelming circumstantial proof end up with absolutely nothing?
Well, it really highlights one of the most perilous illusions in civil litigation. And that's the assumption that a compelling personal narrative, good story, automatically translates into a viable legal claim.
Right, because a story isn't evidence.
Exactly. Today, our mission is to look at the anatomy of this lawsuit, from the initial workplace friction all the way to the judge's final dismissal, to understand the mechanical failure of the plaintiff's case.
And to do that, we are analyzing the factual record and the legal rulings in the case of Arocho-Rodriguez versus Roldan Concepcion.
Out of the United States District Court for the District of Puerto Rico.
Right. And before we begin analyzing the architecture of this lawsuit, we absolutely must issue a mandatory disclaimer regarding the context of this case.
Yes, this is crucial.
Because the sources we are discussing today, they contain inherently politically charged content, specifically involving Puerto Rico's new Progressive Party, which is the MPP, and the Popular Democratic Party, the PDP.
Right. So we want to state explicitly to you, the listener, that we are absolutely not taking any sides here.
Not at all.
We are not endorsing any viewpoints, political or otherwise, held by any of the parties mentioned.
Zero endorsements.
Right. Our job today is strictly and impartially reporting on the allegations, the factual record, and the legal findings contained within this specific court record.
Exactly. We are analyzing the mechanics of federal employment law. The political parties, they merely represent the opposing affiliations required to trigger a First Amendment analysis.
That's all they are for our purposes, Party A and Party B.
Right. So, with that established, let's look at the inciting incident. Because the protagonist here is Jensen Arocho-Rodriguez.
And he's not just some new hire.
No. He's a career employee. He's a system technician coordinator for the municipality of Aguadilla, and he started way back in 2013.
Yeah, and when you look at the undisputed facts regarding his actual day-to-day responsibilities, he wasn't just, resetting passwords.
Right, he wasn't just plugging in monitors.
Exactly. The scope of his role was massive. He was basically the digital architect for the entire municipality.
Yeah, looking at the list here, it's wild. He managed the networks, programmed the computers, he ran the social media, and the official web pages.
He also configured the telephone systems and set up the Microsoft 365 environment.
And wait, he was also the audio technician for public events?
Yeah, and a graphic artist, a video editor, and the official photographer.
Okay, so if a modern municipal government is like a biological organism, this guy was essentially running the central nervous system.
That is a perfect way to put it. The footprint of his job is critical to understanding both his value to the town and, the defense's eventual arguments later on.
Right, which makes what happens next so disruptive, because Arocho-Rodriguez was a known vocal supporter of the new Progressive Party, the NPP.
And of the former mayor.
Exactly. But in the November 2020 elections, power shifts. A new guy, Julio Roldan Concepcion of the opposing party, the PDP, wins the mayoral race.
And he officially takes office in January 2021.
Right, so you have a new boss in town.
And, as is totally standard in municipal transitions, the new mayor brings in his own leadership team.
Right, you want your own people.
Sure. So he appoints Ruben Neves as the director of the Office of Technologies.
Which means Neves becomes Arocho-Rodriguez's new direct supervisor.
Exactly. And the mayor also appoints Maviel Morales Neves as the city administrator. Now, the plaintiff alleges both of these men are active PDP members.
Which immediately sets the stage for a partisan clash in the office. I mean, you can feel the tension building.
Oh, absolutely. And that friction turns into an absolute fire on March 23, 2021.
Okay, let's walk through that day, because it's a lot. Arocho-Rodriguez arrives at work, sits down at his terminal, and finds his access to the municipal server has been completely revoked.
Just totally locked out.
Locked out of the very infrastructure he built and maintains. So he goes to his new boss, Tech Director Neves, who allegedly states the lockout was a direct instruction from the new mayor.
Right. And furthermore, the plaintiff claims he was instructed to just sit in the hallway and wait.
Like a kid outside the principal's office.
Exactly. And 3 hours later, he is summoned to the mayor's conference room for what sounds like, honestly, a tribunal.
Yeah, the lineup is intimidating. You've got the mayor, the tech director, the city administrator, and the city's legal counsel all present.
And they hand him an unsatisfactory performance evaluation.
Right out of the gate. And Arocho-Rodriguez protests this, obviously. He points out that just a few months prior, under the old administration, he received an outstanding evaluation.
Right. And this is where the complaint introduces the first major allegation of overt political animus.
Okay, let's unpack this, because this is the smoking gun, right? The mayor allegedly retorts that Arocho-Rodriguez's outstanding performance had to be at the assembly of the new Progressive Party.
Yeah. The implication being that his only real value was as a political operative, not as an actual IT professional.
Wow. And then, following that meeting, the city administrator comes to the plaintiff's office and hands him a written reprimand.
And when Arocho-Rodriguez objects again, the administrator allegedly tells him to take your case to former mayor Yannitzia Irizarry.
I mean, that is just dripping with political venom. So within a single day, you have a server lockout, a tribunal, a bad evaluation, a written reprimand, and 2 distinct comments allegedly linking his discipline directly to his political affiliation.
Right. And this initiates a 3-week period where the plaintiff claims he is completely frozen out.
Just given no work.
None. Isolated in his office and subjected to continuous mockery by his PDP-supporting colleagues.
And the situation finally ruptures in late April. While the plaintiff is actually on vacation, he is summoned back to the office for a meeting.
Yeah, the mayor accuses him of deliberately withholding vital IT credentials, like the administrative passwords to the servers and the municipal telephone board.
Which, if true, is a massive security risk. But Arocho-Rodriguez pulls up an email right there in the meeting, proving he had already sent those exact credentials to the mayor.
But instead of de-escalating, the mayor allegedly calls him a liar, terminates the meeting, and has him escorted out of the building by armed municipal police.
Which is, armed police.
Yeah. And then, a month later, citing severe physical and emotional distress, Arocho-Rodriguez resigns. He claims he was constructively discharged.
Meaning he was essentially illegally forced out.
Exactly. Now, when you lay out the narrative chronologically like that, it feels incredibly cohesive. I mean, the plaintiff's legal team is painting a picture of a coordinated, politically motivated purge.
Right. I look at that timeline, and my immediate instinct is that the new administration clearly wanted their own guy in that vital IT role.
It looks that way.
They couldn't just fire a career employee without cause, so they orchestrated a campaign of humiliation to make him quit. But obviously, the defense isn't just going to accept that narrative.
No, of course not. They have to establish a counter-narrative, right? It's a completely different version of reality just to halt the momentum of these allegations.
And they do this through the legal mechanism of the defendant's answer to the complaint. It's like a tennis match. Every aggressive serve from the plaintiff is volleyed back with a flat, absolute denial.
It is a vital procedural step. What's fascinating here is how the defense systematically denies the allegations of political persecution. But more strategically, they begin severing the legal connections the plaintiff is trying to rely on.
Right. For instance, the defense explicitly denies that Mayor Roldan Concepcion even knew the plaintiff's political affiliation.
Which is a massive structural attack on the plaintiff's story.
Because if the ultimate decision maker doesn't know your politics, he literally can't be firing you because of your politics.
Exactly. And the defense goes further. Tech Director Ruben Neves, the direct supervisor, he legally denies even being a member of the PDP.
Oh, wow. So they are just dismantling the whole premise.
Yeah. By doing that, the defense is attacking the foundational premise of a political conspiracy. They are framing this not as a partisan purge, but as a standard operational dispute.
They assert that his work performance was actually interfering with the municipality's operations.
Which, makes sense from an administrative perspective.
Yeah, I mean, if you were a new mayor taking over a city and the one guy who holds all the digital keys to your networks, your communications, your public messaging, if that guy is suddenly acting adversarial, that's a massive security vulnerability.
Absolutely. The defense is suggesting the lockout and the police escort weren't like political theater. They were emergency operational security measures.
Okay, that actually tracks. So beyond the factual denials, the defense also deploys what are called affirmative defenses.
Right. These are essentially legal circuit breakers.
They are arguing that even if a jury fully believed the plaintiff's version of events, the lawsuit still fails based on legal precedent.
And the most potent of these in a municipal context, which they use here, is qualified immunity.
Okay, let's drill down into qualified immunity, because we hear that term constantly in the news, usually regarding police conduct, right? But it plays a huge role in employment law, too.
It really does.
The basic concept is that government officials can't be personally sued for doing their jobs unless they violate a right that is so clearly established that any reasonable official would have known their conduct was illegal.
Exactly. It's a shield against Monday morning quarterbacking by the federal courts.
Right. It protects officials from frivolous suits.
Precisely. And invoking it early is the deliberate strategy. The defense is signaling to the judge that the plaintiff isn't just fighting a factual battle about who said what.
He is fighting a steep uphill legal battle against sovereign protections.
Yeah. And this sets the stage for the pivotal phase of the litigation, where the court must decide if there's actually enough evidence to justify a trial.
Which brings us to the absolute core of our analysis today. The magistrate judge's report and recommendation regarding the defendant's motion for summary judgment.
Summary judgment, Rule 56.
Right. I want to replace the tired metaphor of where the rubber meets the road, because summary judgment is essentially a load-bearing test in architectural engineering.
I like that analogy.
Right. The plaintiff has drawn a beautiful, compelling blueprint in his initial complaint. But at summary judgment, the court starts piling massive concrete weights onto that structure to see if it instantly collapses before they ever let a jury walk inside.
That is a highly accurate way to frame Rule 56 of the Federal Rules of Civil Procedure.
Because the storytelling phase is over.
Right. Once the discovery phase concludes, once both sides have had the opportunity to demand emails, take sworn depositions, subpoena records, that grace period of just alleging things ends.
Time to put up or shut up.
Exactly. The moving party, which is the defense here, tells the judge, look at the actual evidentiary record. There is no genuine dispute about the material facts. We win as a matter of law.
And for a First Amendment political discrimination claim, that load-bearing test is incredibly rigorous.
It really is. The magistrate outlines a very specific four-pronged legal standard derived from established precedent, primarily the Mount Healthy case.
Right. And if the plaintiff's evidence fails to support even one of these four pillars, the entire case collapses.
Yeah. The Mount Healthy doctrine is foundational here. It originated back in the 1970s.
With a school teacher, right.
Right. A teacher who was fired after calling a radio station to complain about a school dress code.
Which is a protected First Amendment activity. You're allowed to speak out.
Exactly. But the problem was he had also been involved in several other incidents, like making obscene gestures at students.
So the school had other very valid reasons to fire him.
Right. So the Supreme Court had to figure out how to handle these dual motives. They established that a plaintiff first has to prove that their protected conduct, the political speech, was a substantial or motivating factor in the adverse action.
And if they prove that,
then the burden shifts to the employer to prove they would have taken the same action anyway, even without the protected speech.
Like, we would have fired him for the obscene gestures anyway.
Exactly. So adapting that to political discrimination in Puerto Rico, the magistrate requires Arocho-Rodriguez to clear 4 distinct hurdles.
Okay, let's go through them. Prong 1. Opposing political affiliations. The plaintiff is NPP, the administration is PDP.
That pillar holds, the evidence supports it.
Okay, but prong 2 is where the structure fractures. The plaintiff must present actual evidence that the specific defendant who took the adverse action was aware of his political affiliation at the time the action was taken.
And when the magistrate reviews the depositions and the documentary evidence, she finds a total vacuum.
Nothing.
There is absolutely zero evidence that Mayor Roldan Concepcion knew Arocho-Rodriguez was an NPP supporter before ordering the server lockout.
This exposes what we might call the danger of ambient knowledge in corporate or municipal culture.
Oh, that's a huge issue.
Employees often assume that because a workplace, feels a certain way, or because gossip flows freely, the law will just recognize that culture as an established fact.
Yes.
I see this constantly in organizational behavior. Arocho-Rodriguez literally argued in his deposition that everybody in the municipality knew that he was an active militant of the NPP.
He just assumes it.
Right. He thinks, I was highly visible under the last mayor, therefore the new mayor must inherently know who I am.
But ambient knowledge is inadmissible at summary judgment.
It's not proof.
Right. The rules of evidence require specificity and causality. Did the mayor interact with him politically prior to taking office?
No evidence was presented.
Did the mayor attend an event where the plaintiff was campaigning?
No evidence.
Did anyone testify under oath that they specifically informed the mayor of the plaintiff's affiliation before March 23rd?
No.
Exactly.
It points to a catastrophic failure during the discovery phase. This is the period where the plaintiff's lawyers had subpoena power.
They had the tools to get the proof.
Right. They could have deposed the mayor and cornered him on his knowledge. They could have subpoenaed internal transition emails between the new team discussing the holdovers from the old administration.
Yeah. If everybody knew, the lawyers should have easily found 3 colleagues willing to sign sworn affidavits stating, I personally discussed the plaintiff's NPP loyalty with the mayor.
But they produced nothing but the plaintiff's own assumption. Just his own words saying they knew.
Which brings us to prongs 3 and 4 of the test.
Okay. Prong 3 requires an adverse employment action.
And the magistrate agrees that locking someone out of their server, issuing reprimands, and a police escort, yeah, those qualify.
So that pillar holds, but prong 4 is the final fatal choke point. Was political affiliation a substantial or motivating factor for those adverse actions?
Right.
Now, here's where it gets really interesting, because I want to push back on this analysis for a moment. This is where the strict application of the law feels entirely detached from human reality.
Okay, how so?
Let's look at the timeline again. On the exact same day the mayor locks him out of the server, the city administrator hands him a reprimand and explicitly says, take your case to former mayor Jensen Arocho-Rodriguez.
Right, the political comment.
And later, the mayor allegedly makes a snide comment about the NTP assembly. If prong 4 requires proof of political motivation, don't those explicit partisan insults fulfill that requirement? How can the magistrate say there's no evidence of motivation?
This raises an important question. And the answer is because the law demands that we isolate the chain of command.
Isolated how?
This introduces a vital concept in employment discrimination, often referred to as the cat's paw theory, though here it actually operates in reverse.
Okay, cat's paw, that comes from the old fable, right? About the monkey tricking the cat into pulling roasting chestnuts out of the fire.
Yes, exactly.
The cat burns its paws doing the monkey's bidding.
Right. In employment law, the monkey is a biased middle manager, and the cat is the unbiased ultimate decision maker.
Okay, so the boss is the cat.
Right. If a biased supervisor manipulates an unaware boss into firing someone, the company can still be liable. The supervisor used the boss as a cat's paw.
Got it. So the bias flows up.
Exactly.
Yeah.
But here, the magistrate conducts a surgical analysis of the hierarchy and finds that the cat's paw theory does not apply because the ultimate decision maker acted independently. Okay, let's break that down. The city administrator, Morales Neves, is the one who allegedly made the comment about the former mayor.
Yes. But it is an undisputed fact in the record that Morales Neves did not have the authority to lock the plaintiff out of the server, nor did he make the decision to do so.
Only the mayor gave that instruction.
Exactly.
I see the isolation now. The guy who made the political comment didn't pull the trigger, and the guy who pulled the trigger hasn't been proven to possess any knowledge of the plaintiff's politics.
Precisely. The magistrate writes that because there is no evidence the city administrator participated in the actual employment decisions regarding the server or the police escort, any comments made by him cannot be legally deemed as evidence of a motivating factor for those specific adverse actions.
Wow. So you cannot legally attribute the animus of a middle manager to the independent actions of the chief executive? Nope. They are separate entities legally.
And as for the mayor's alleged comment about the MPP assembly, the one he made during the tribunal,
the magistrate notes that even if the mayor made that comment during the tribunal, temporal proximity alone is insufficient.
meaning just because things happen at the same time doesn't prove one caused the other.
Right.
I get the logic there. I mean, if merely firing someone right after an election was enough to prove discrimination, a new administration could never restructure their vital departments. The government would be paralyzed.
Exactly. You have to prove actual causation, not just coincidence.
But I keep coming back to the plaintiff's ultimate resignation. He didn't just get reprimanded. He was escorted out by armed police. He claims he was forced to resign a constructive discharge.
Constructive discharge is a fascinating area of the law because it requires a dual analysis.
Okay.
An employee might genuinely, subjectively feel that they're being tortured at work. They might suffer sleepless nights, severe anxiety, exactly as Arocho-Rodriguez claimed in his resignation letter.
Right. It feels real to them.
But the legal standard is brutally objective.
It relies on the reasonable person standard.
Yes. The court isn't asking if this specific plaintiff felt forced to quit. They're asking if a hypothetical, average, reasonable person would have felt compelled to quit under the exact same material circumstances.
Right. The working conditions must be so objectively onerous, abusive, or unpleasant that a reasonable person would have no choice but to resign.
And here, the magistrate notes a critical failure in legal advocacy.
Another failure by the lawyers.
Yeah. The plaintiff's lawyers alleged constructive discharge, but they completely failed to connect the facts of his day-to-day experience to that objective standard through developed legal argumentation.
Which transitions us perfectly to the climax of this legal failure, found in the final document, the memorandum and order from Senior District Judge Francisco A. Besosa.
Right, because the magistrate only makes a recommendation. Judge Besosa holds the final authority.
Exactly. And when the plaintiff files his objections to the magistrate's report, he basically just repeats his original mantra.
Yeah, he points back to his own deposition and says, "But Judge, everybody in the municipality knew I was an NPP militant."
He is still relying on ambient knowledge, hoping the senior judge will just ignore the evidentiary rules the magistrate just applied.
Which is never a winning strategy.
No. Judge Besosa delivers a definitive reality check, affirming that allegations and speculation are entirely insufficient to survive summary judgment. But the judge goes further, identifying the cardinal sin committed by the plaintiff's legal team.
Oh, this is the worst part.
He states that undeveloped arguments are waived. I want to spend some time on this because it explains the silent mechanics of how lawyers actually win or lose cases on paper.
It's all about the briefing.
Right. In law school, they drill a specific writing method into you for drafting briefs. It's called IREC Issue Rule Application Conclusion.
Yes. IREC, you state the legal issue, you cite the established rule of law from precedent, you meticulously apply that rule to your specific facts, and you state your conclusion.
It's a formula. And reading Judge Besosa's order, it becomes incredibly clear that the plaintiff's lawyers essentially provided the issue in the rule and then just stopped typing.
They skipped the most important part.
They cited previous court decisions about constructive discharge and political discrimination, but they offered zero application. They didn't build the bridge between the precedent and Arocho-Rodriguez's specific suffering.
They essentially threw a textbook at the judge and said, the math is in there, you figure it out.
Which is wild.
Yeah.
And the judge responds by saying, if you advert to an issue in a perfunctory manner, unaccompanied by some effort at developed argumentation, it is deemed waived.
Meaning you lose the right to even rely on that law.
This speaks to the absolute neutrality required of the judicial branch in the adversarial system.
That is the core philosophy of American civil litigation. The judge is a referee, not an advocate. Even if Judge Besosa reads the file, looks at the timeline, and thinks to himself, there is probably a valid legal argument for constructive discharge buried in this mess, he is constitutionally prohibited from constructing that argument on behalf of the plaintiff.
Because doing so would be practicing law from the bench.
Exactly.
It would blindside the defense, who only have the right and the obligation to respond to the arguments actually presented by opposing counsel, not the arguments the judge wishes they had presented.
Precisely. If the plaintiff's counsel fails to execute the application phase of the brief, the judge cannot ethically build that bridge for them. The system prioritizes procedural fairness and the rigorous burden of proof over, omniscient justice.
It is a harsh reality.
Very harsh.
If we connect this to the bigger picture, it forces us to acknowledge that having a righteous grievance, even if we assume for a moment that Arocho-Rodriguez was completely telling the truth and was maliciously targeted, is only about 10% of a successful lawsuit.
Yeah, 10% at best.
The other 90% is the tedious, rigorous execution of admitting evidence into the record and actively synthesizing that evidence with precedent.
And because the execution failed so thoroughly here, Judge Pesosa adopts the magistrate's recommendation in full and dismisses the First, Fifth, and 14th Amendment claims with prejudice.
Prejudice. Meaning he can't file it again. Game over.
Game over.
So what does this all mean? When we synthesize this entire stack of documents, what are the actionable takeaways for you, the listener?
Well, the most glaring lesson is the devastating distinction between subjective belief and objective proof.
Right. If you ever find yourself facing what you believe is workplace retaliation, whether based on politics, race, gender, or whistleblowing, your internal certainty is legally irrelevant.
It doesn't matter how sure you are.
No, you cannot walk into a federal court armed only with your outrage and a reliance on what everybody knows.
You must have objective documentation. You need emails, you need witness affidavits, you need a verifiable timeline that proves the specific individual who authorized your termination actually possessed the requisite knowledge of your protected status before they took the action.
Without that, you have nothing. We also have to reinforce the standard of causality here. Proximity does not equal causation.
Say it again for the people in the back.
Right. Getting fired immediately following a change in leadership or immediately after filing an HR complaint feels inherently suspicious.
It definitely feels that way.
But suspicion doesn't survive a load-bearing test at summary judgment. You have to prove the specific causal link between the two events.
And critically, you must map the chain of command within your organization. As we saw with the cat's-paw analysis, the courts isolate liability.
Right.
If a middle manager holds discriminatory animus, but upper management independently executes a termination based on objective operational needs, like, securing a compromised IT network, the middle manager's bias may be entirely neutralized as a legal factor.
It requires a plaintiff to be incredibly strategic about identifying who actually made the decision and what information that specific decision maker was relying on.
Absolutely.
I want to circle back to a final thought regarding the constructive discharge standard because it poses a really fascinating philosophical question about the modern workplace for you to mull over.
Oh, this is a great point to leave on. The requirement that conditions be objectively onerous to a reasonable person.
Right. The law deliberately ignores the subjective emotional distress of the actual employee in favor of a hypothetical average standard.
Yeah, it doesn't care how the plaintiff actually felt.
But does that objective standard inherently punish highly sensitive employees?
Yeah.
I mean, if an individual naturally possesses a lower threshold for conflict and a hostile corporate environment breaks them down and forces them to quit much faster than it would break down an average person, the law essentially tells them their suffering doesn't count.
It's a compelling tension.
Oh.
Conversely, though, you have to look at what that objective standard is designed to prevent.
Which is what?
It protects employers from the paralyzing threat of litigation every time an employee misinterprets standard corporate friction or a demanding new manager as targeted illegal harassment.
Wow, yeah. It forces us to define the boundary between a legitimately terrible day at the office, which is perfectly legal, and a federal civil rights violation.
The law basically expects employees to possess a certain amount of resilience against the ordinary slings and arrows of professional life.
It challenges everyone to consider how much discomfort is legally acceptable and when management's behavior actually crosses the line from abrasive to objectively intolerable.
It is a difficult line to draw.
It really is, and it requires extraordinary precision to prove you've been pushed across it. Which brings us right back to the fundamental lesson of Arocho-Rodriguez. You might genuinely believe your career has been destroyed by illegal motives. You might feel the injury deeply.
But when you step into the arena of federal litigation, if you cannot provide the specific objective evidence proving the mechanics of that injury, if you fail the load-bearing test, the system will determine that, legally speaking, no injury occurred at all.
And your case will be dismissed with prejudice. Thank you for joining us as we unpacked the rigorous mechanics of employment law and the absolute necessity of proof. We will see you next time.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to C-A-R-E-Y, at capclaw.com. That's capclaw.com.